one of my early days within Zelo, wherein we're conducting a mobile legal clinic in the Manicaland area. We did come across a community there that had, that faced some violations of their constitutionally entrenched rights. And one lady actually did mention, in terms of that quote that I have put right there, mvura yedu yakaenda, munda wangu wakaenda, vakavunza ani, umuzi wami wakahamba, umhlabathi wethu wathathwa, babuzubani, basically. So in terms of that statement, in terms of my water is gone, my field is gone, who did they ask? Despite knowing, Section 73, of course, of the Constitution, you can probably sing it, environmental rights, the Environmental Management Act and all that. She didn't ask about the Section 73 or the Environmental Management Act, but just that in terms of her lived reality. So that is the moment, I think, you realize how community experiences, or sometimes how the law, in terms of theory, can also be quite distant when it comes to the practice on the ground. In terms of some estimates or statistics from academic sources, they state that about 70% of our population resides in rural areas. And that's not a small statistic, as you can see. And these people are dependent on the rivers, on the land, and sometimes you do find that mining operations or extractivism, they are transforming the landscape within these areas, sometimes without their genuine consent, and people are excluded from processes, although our own laws that are designed to protect them do have some protections within them. So the story that I've mentioned is not a tragedy per se. It was representative, and it also highlights a pattern. And today, I think that's what I'm trying to kind of speak to, in terms of that pattern that we have when we look at the theory that is there around environmental rights protection, around participation that is entrenched within our Constitution, and what actually then transpires on the ground. So there is a central paradox that is existent. So I'll try to state this quite plainly. So you do find that Zimbabwe has got one of the most progressive constitutions or environmental rights frameworks on the African continent. I know some people usually tease us that we copied verbatim the South African Constitution, maybe with a few variations, here and there. But it's it's still a fact that it's one of the most progressive constitutions out there. And Section 73 of our Constitution in that regard is genuinely exceptional when you look at it. And the Environmental Management Act as well creates real obligations, or the Environmental Management Act actually brings to life the constitutional promise of environmental rights protection. Also, additional to the Environmental Management Act, we have Statutory Instrument 7 of 2007, which generally outlines the environmental impact assessment process. And I note that I've been talking so much about the environmental impact assessment, and I think when it was asked how many of us are even doing environmental law, I think quite a few actually raised their hands. So an environmental impact assessment, plainly put, is the participatory process that is done before a project comes to a certain area. So you do find that there are certain projects that are listed within the first schedule of the Environmental Management Act that ought to have an environmental impact assessment. So you do find that when it comes to buildings, there needs to be an environmental impact assessment. When it comes to irrigation schemes, when it comes to construction of stadiums, of dams, when it comes to mining, all those require environmental impact assessments as a matter of law. So that is the process we are referring to here. That is even before a mining company gets an exploration license, a mining license. They first need to attain that environmental impact assessment. So you do find that despite us having all those laws from Marange there, you know, diamond mining, diamond fields in Marange, to Wange, the coal and coking plants that we have there, to Zvishavane, gold and other various minerals that are there, to Bikita, right next door here now when we're talking about lithium mining. So despite us having the law, and we note all these mining operations happening throughout Zimbabwe, communities are at times being displaced. Rivers are being contaminated. I note a case, I think Matezwa Dam was recently contaminated after a spill of the tailings dam. So you also find that forests are being cleared. You find that ultimately futures are being foreclosed, and this is without their genuine knowledge or consent for that matter. And both of these things, they do happen simultaneously. And the coexistence of these two truths that I'm mentioning here is the central legal challenge that we have right now within Zimbabwean environmental governance. So you find that the Constitution in itself gives our communities a voice. It gives us all a voice. And the EIA, the Environmental Impact Assessment, gives it a form. What kind of form, you might ask? It's a form in English. It's a form with a 30-day response period from the time it's initiated. It's a form of about 400-page plus or minus technical document. And ultimately, as you can see, for a rural community, probably down in Marange there, down in Cholocho, down in Lupane, or wherever you might think of, that is not participation per se. That is the performance of participation, because ultimately it's almost done at the benefit sometimes of the project proponent or the project developer. And it is conducted over the heads of the people that it was designed ultimately to protect. So that performance, as I highlight, it does fail communities in three distinct ways that I'll highlight. One, it's a matter of distribution. As a matter of distribution, distributive injustice. Two, as a matter of procedure, procedural injustice. And three, recognitional injustice, a matter of recognition. So you do find that it fails to distribute environmental burdens fairly, because the environmental impact assessment ultimately is supposed to look at the pros and cons of a particular project happening in an area, and the environmental burdens, if they far outweigh the benefits, that project, at least by implication or by theory, should not proceed. Secondly, we did mention that it fails to include communities in decisions. That is now the procedural aspect, the procedural injustice that we mentioned. Communities are not, it fails to include communities in the decisions. Communities are excluded from or marginalized in the decisions that create those environmental burdens. And thirdly, it fails or it refuses to recognize their knowledge and culture. Sometimes indigenous knowledge, cultural knowledge, traditional knowledge is kicked to the periphery. It is not necessarily brought to the mainstream. So sometimes you do find that those community languages, the indigenous knowledge, cultural relationships with the land are not really recognized as valid inputs into governance at the end of the day. So each failure that we note here, it's a distinctive wrong, if we put it that way. And ultimately, when you look at the law, if you now become practitioners, the most powerful, I think, environmental rights cases would plead all three of these simultaneously. So, in terms of where this law is actually grounded, where are we coming from? So all we're mentioning when you look at extractivism, it's reliant as well on the land, right? Because you cannot have mining probably without the land that is there. And you do find that there are various uses of land. There's various tenure of land that we have within our Zimbabwean system, leasehold, freehold, and offer letters, etc., etc. So we've got various, we've got a quite broad land tenure regimen. So you do find that there's a history to it, to where we find ourselves today. So communities are excluded from the environmental impact assessment process today at times. These are communities that were stripped of their best agricultural land under the Land Apportionment Act of 1930. I think if you know our history and all that, British South Africa Company, etc., that is when the establishment of Kuma Reserve, reserves. So that is when people were actually then placed in reserve land. So that came about because of the Land Apportionment Act. And also, people were confined to what we call communal areas by a system. It was a system that was meant to ensure that the people who worked on that land did not actually own it. And this point is quite relevant as I proceed with this conversation. Independence came, the Constitution came, the Lancaster House Agreement. We had various amendments, to our Constitution up until Amendment number 20 that came in 2013. And that's when now we find Section 73 of our Constitution in that 2013 Constitution. But even though that Constitution came, that colonial legacy or that architecture around land tenure still remained, or it was not dismantled. So, and there's a new mining industry right now that has arrived in those very same communities. Those very same communities that were displaced back in 1930, that is where now the mining is also happening. And we are operating within that same legal architecture that colonial law created, and that is the weight ultimately when you look at environmental law. Not just a developer with an environmental impact assessment per se, but a structure that has told communities their relationship to their land does not fully count since 1930. What do I mean by that? I think if we're following some conversations around a case in Chirez, the Livson Chikutu case, wherein there was a challenge against Section 10 of the Communal Land Act, which basically is the import is basically to say if you stay in a communal area or stay on communal land, you cannot own that land. So the Constitutional Court actually ruled that that provision was constitutional. So you find that we are still sort of like working within the ambit of that same structure of the legal system. Now, according to our Constitution, what it actually says when it comes to Section 73. Every person has the right to an environment that is not harmful to their health or well-being, and to have the environment protected for the benefit of present and future generations through reasonable legislative and other measures. So, as you can find there, the crafting of this provision was quite strategic in terms of how it was put. The framers chose justiciable language. Justiciable language in the sense that if this right is violated, you need to have access to an effective remedy. So that is what the framers, I think, envisioned in terms of the language that was used in the framing of that provision. And also, this right is enforceable under Section 85 of our Constitution, Section 85 being the one that grants us locus standi, to those who love Latin. So we do find that it's quite a strong provision within our Constitution, and you find that within the Declaration of Rights, they are not easily derogable, unless maybe for particular instances that are outlined within Section 86 of our Constitution. So this right can be read, should or must be read alongside several other provisions that we find within our Constitution, whether be it Section 77 of our Constitution, which speaks of a right to a safe, clean and potable water, whether you're looking at Section 56, which speaks of discrimination, equality, that anti-discrimination clause, whether you look at it from Section 62 of our Constitution, that highlights issues of access to information, whether you look at Section 68 of our Constitution, that looks at administrative rights. So there is a whole plethora of rights that are entrenched within that Chapter 4 that can be read alongside this Section 73. So what those words mean basically is quite strong. Every person, it's not just citizens, not property owners, but every person. Secondly, has the right, is justiciable, is directly enforceable through the High Court, which is that original jurisdiction. And Section 85 therefore also highlights that any person can enforce it. There is no direct harm required. I know my brother said, work opportunities, you can work at Zelo, so even if Zelo is not directly affected, Zelo can probably represent a community down in Jocholo there or in Uzumba Maramafungwa. So yeah, that is the import of that Section 85. So the environmental impact assessment now, in terms of what the law actually promises of this process. Below the Constitution, the Environmental Management Act, and Statutory Instrument 7 of 2007, they give, the participatory right its operationalization or its operational mechanism, if I can put it that way. So the environmental impact assessment is the law's answer basically to a fundamental question that exists within the conversation around environmental law. Who gets to be in the room when decisions are made about land and water that communities depend on? So basically that is the answer that is the question that the environmental impact assessment process seeks to respond to. And the answer in principle is that affected communities must be notified, affected communities must be consulted, and their objections must be genuinely considered before any mining license is granted. And this is basically Section 73 of our Constitution, given the legs or the life that we've been trying to mention, and also it's Section 73 being given a timeline in terms of when it should actually happen. So The EIA, the environmental impact assessment, basically is the law's promise that the woman in Mashonaland that I did highlight there will be in the room when the decision is made about their environment, not after the trucks probably arrive or not after they are being displaced. So that promise, unfortunately, and at certain times, maybe more often than not, has been systematically broken. So I am going to describe how the participation or how consultation works in practice at times. Beyond the theory, forget what's in the textbook, forget what's in the law, but how it actually then transpires on the ground. So you find that, and as I describe it, I think you note something very important. Everything that I'm going to say, technically, it's legal. It's technically, it will be legal. But then it's about the system of it. And I think that's something we'll try to just expose or bring to life. So it's more a story about a system that violates at times the spirit of constitutional safeguards while perfectly complying with its letter. What do I mean? It's almost sort of like a lawful injustice, if I put it that way. And it is harder to name than a simple illegality, at times. And illegality, it's easy to pick out and point out and easy to address, but it's sort of like lawful injustice, that's now quite difficult. More so if that community member or if that woman in Manicaland does not have access to legal representation. So you find that a mining company acquires an exploration license from the Ministry of Mines. It commissions an environmental impact assessment. That's a mining company. That is the one that also commissions the environmental impact assessment. A notice is published, probably in English, in a national newspaper. That is what the law actually says. A 30-day response window opens. The affected community, probably speaking Ndebele, Shona, Tonga. We've got 16 officially recognized languages within our constitution. So that community probably does not maybe speak the language within which those developers or the environmental impact assessment is being undertaken. And also with probably no access to the newspaper in those rural communities, no legal representation at that material moment in time, no capacity to interpret a hydrological impact assessment, because that's what they'll be talking about at those meetings. Theoretically, the developer or the environmental impact assessment practitioner can then say, we have informed the community and we have conducted consultation. But ultimately what it is, it just becomes sort of like a theater in Zimbabwe. And also there is the first woman to actually win a Nobel Peace Laureate, Wangari Maathai. She actually said responsible governance of the environment was impossible without democratic space. What that meant was our communities are being denied that democratic space in the name of a transition they did not cause and from which they do not equally benefit. And that is not a just transition. That is not a just transition per se, because ultimately when we speak of just transition, there is an element of justice that needs to be there. Of course, I know the debates around what justice actually is still an ongoing debate, but ultimately, I think we need to see the communities benefit from the natural resources within their areas. So a conversation that is happening within the global space right now is around what they call supply chain due diligence, human rights due diligence, corporate sustainability due diligence, all those kind of issues. So I'll call it maybe the supply chain as an accountability level. So it's not all doom and gloom, it's not that communities are not being consulted and so on. But then you do find that 138 of the world's major banks have signed the Equator Principles. So in terms of the Equator Principles, basically they put in place certain standards or measures or minimum measures that they put in place, such that whenever maybe a project developer, a project proponent, a mining company wants to access that capital, we're talking about that financing, they have to meet that minimum threshold. And according to Equator Principle 4, that took in effect 2020, these banks have made a binding commitment that they will not finance projects that do not comply with EP4 standards, Equator Principle 4 standards or requirements. And EP4 requires genuine stakeholder engagement, independent evaluation of the consultation process, free, prior and informed consent assessment, a human rights impact assessment, and a climate change risk assessment. So that's EP4, Equator Principle 4, there to say the banks will not give a company money if they do not prove that they have conducted all those processes. And also, if the bank financing a mining project in Zimbabwe is one of those 138, it is very unlikely communities have a complaint mechanism to actually approach. So if a community down in Manicaland, down in Matabeleland South, have an issue and this company was financed by one of these 138 banks, then you do have recourse to that internal grievance redress mechanism. But it's not easy, because as you will find, as you grow within the profession, beneficial ownership of companies is very hard to prove. Who actually owns what? Companies are hidden underneath subsidiary companies and all those other issues that are there, which is probably not the subject of today's conversation, but I think it's something that you can always look up. And also, when you're looking at the European legislation, in August 2023, the European Union enacted a battery regulation, regulation 2023/1542, and from 2027, that is next year, every electric vehicle battery placed on the EU or European Union market must carry a digital passport, battery passport, basically. So what that means, there's going to be a QR code that is there that someone can easily scan for tracking the supply chain from raw mineral extraction at Bikita there, or whether at Prospect Lithium, at Kamativi, all the way to the end life. That is within our Teslas, our BYDs, and so on. So there is that regulation that kicks in within the European Union framework. So the lithium extracted in Bikita, processed in Bikita, since nowadays, as well as Zimbabwe, we are pushing for local beneficiation, processing within our borders, shipped and placed in a vehicle, whether in Frankfurt, Copenhagen, etc., will be traceable back to its source, including the community consultation that I made mention of, the community consultation record at the mine site, the community that was given a 30-day notice in English and told that was participation. Their exclusion basically now will be auditable, if we can put it in those terms. It will be auditable, it will be traceable, and it will be a basis for liability for every company downstream that sourced without conducting adequate due diligence. So that is what this EU regulation, or the import of that regulation, basically means. So I think as I draw to an end, so basically the world that we're going to pass on from now onwards, I think as law students in here, we do have an opportunity, going forward, for us to actually be advocates. I think my brother, they mentioned that he can be an advocate going forward. So we can be advocates, for environmental protection. What what world our Zimbabwean community is actually inheriting? What are we inheriting as Zimbabweans from the extraction that is happening within our communities? Section 73 in our constitution and silence in the environmental impact assessment, archaic land law, and a new mining industry that is built built on its architecture, Zimbabwe's minerals powering a clean energy transition that never asked permission, basically speaking. So this should be a reminder to us as well to say the law is existent, it's there, the protections can be there, but the law as well does have its limitations at the end of the day. But we do see that fundamental protections have been entrenched within our constitution, which we can utilize as lawyers going forward. Additionally as well, we see there's a global pull or a global push towards, due diligence across value chains. So that's also an entry point for us as lawyers. But I'm not saying this is very easy in any way, because ultimately as well, you're going against huge capital. The people who are involved in these operations, it's not quite it's quite a huge task. And the law takes time. It's not something that you go to court today and you've got a judgment in 2 days, 3 days, or a week, a month. But these are cases that can take years on end. So ultimately, as environmental lawyers, you do need to have that patience in you when you are conducting these environmental litigation, basically. And with that, I hope it made sense to you, and you might be inspired maybe to take up environmental law going forward. But that's what I had for you today in terms of my presentation. Thank you.